Welcome to This Explainer. Today, we're diving into a genuinely fascinating and honestly pretty messy real-world legal dispute. We are looking at a hidden plumbing leak that pits a brand new condo owner right against her homeowners association. It's basically the perfect case study in property law, liability, and, well, those nasty hidden surprises that can pop up when you buy real estate. So picture this. You just bought a new condo. You're getting settled in, finally making the place your own, and then, out of nowhere, disaster strikes. You find out a massive water leak from your unit is actively destroying the ceiling of your downstairs neighbor. Talk about panic-inducing, right? It immediately brings up the million-dollar question, who is legally on the hook to pay for all this damage? Is it you, the brand new owner, or is it the HOA?
Just imagine the real-world stakes here. We're talking about severe water damage in Unit 620, which sits directly beneath the newly purchased condo of our homeowner, Tatiana Hernandez. We're talking bubbling paint, completely ruined drywall, and just a massive, incredibly stressful headache for everyone involved.
Let's completely unpack this official legal dispute between Tatiana and the Barcelona Manor Association. We're going to go through the evidence step by step, almost like we're the jury in the courtroom, so we can understand exactly how liability gets decided in these complex, shared living situations.
The whole conflict really boils down to this crazy contrast. Up top in her unit, Tatiana has this perfectly pristine, beautifully tiled bathroom. Looks amazing. But hidden beneath her floorboards, tucked away in a completely inaccessible ceiling cavity, sits a disastrously failing pipe. The problem isn't out in the open where she can see it, it is literally buried in the building's architecture. Okay, let's start with Tatiana's side of the story. Her main defense is all about the physical location of those pipes, and she makes a really logical point here. She argues, how can she possibly be held liable for maintaining plumbing that she can't see, can't reach, and can't even inspect? In her mind, her liability should stop exactly where her physical access stops. Makes sense, right? To back this up, she points straight to Section 9.1 of the community's governing documents, the CC&Rs. She reads this text as saying that anything outside her immediate paint-to-paint unit boundaries, like, say, a pipe buried down in the floor joists, is strictly the HOA's problem to fix and maintain.
So she builds her defense on some pretty undeniable facts. First, she definitely didn't install the faulty plumbing herself. Second, she claims she had absolutely no prior knowledge of it. Plus, the pipe is totally inaccessible to her. And despite all that, she has been 100% cooperative with the HOA since the very minute the leak was discovered.
I mean, her text messages to the HOA show her acting in total good faith. Get this, she actually voluntarily stopped using her only shower. She chose to go shower at her gym for 6 full months while this whole dispute raged on. She brings up this huge personal inconvenience to prove that she absolutely was not acting negligently.
Well, as you might guess, the Barcelona Manor Association paints a very different picture. The HOA argues that liability doesn't just magically stop at the drywall. They say it's actually the nature of the pipe, rather than its physical location, that dictates who ultimately has to pull out their checkbook.
See, during the investigation, the HOA's contractor uncovered a massive issue. They found an illegal, completely non-code compliant P-trap drain that was installed by the previous owner. And here's the crucial detail. The HOA points out that this specific pipe serves only Tatiana's tub. It is not some shared building pipe, it is completely exclusive to her unit.
This sets up such a fascinating legal standoff. On one hand, you have Tatiana's strict boundary interpretation. Basically, it's outside my walls, so it's the HOA's problem. But pitted directly against that is the HOA's argument about exclusive use fixtures. Their stance is, it only serves your unit, so it's an owner responsibility. And they argue that holds true regardless of where the pipe physically sits in the building's framing.
The HOA actually leans really heavily on Section 9.4 of the community rules for this. That section specifically states an owner must pay for damages caused by the act or neglect of an owner. The HOA's logic here is that the illegal, non-code installation by the prior owner was undeniably an act of neglect.
And the HOA representative, he stated it incredibly bluntly during the hearing. He essentially said, look, when you buy a condo, you unfortunately buy its problems. Whether you personally caused the bad plumbing or not doesn't matter. The moment your name goes on that deed, the liability transfers straight to you.
So we have these two really compelling arguments. But the entire trajectory of this hearing completely changes when we look closely at the documentary evidence. The administrative law judge started digging into the paperwork from the original sale of the condo, really hunting for clues about what was known and, more importantly, when it was known.
Tracing the exact sequence of events here is absolutely critical. So before 2025, there was a prior plumbing repair done by the old owners. Then, in August 2025, Tatiana purchases the unit. Fast forward just a bit to October, and that severe leak is discovered by her downstairs neighbor. And finally, by April 2026, everyone is sitting in front of a judge.
Well, that judge found a major smoking gun right in the seller's disclosure form. Remember how Tatiana claimed she had no prior knowledge? It turns out the official disclosure explicitly listed a prior tub leak. Lines 172, 175, and 285 detailed that a rooter company had come out, performed a minor plumbing repair, and tightened a drain nut, all before Tatiana ever even closed on the property. Legally speaking, she was on notice.
So, with all the facts, the community rules, the timelines, and those disclosure documents laid out impartially, Administrative Law Judge Sandra J. Vanella had to make the tough call. On April 29, 2026, she issued her final, legally binding decision on exactly who had to pay for this hidden leak. Citing Arizona state law on condominium upkeep, the judge pointed out a really key distinction. Yes, the association absolutely has to maintain common elements. But this specific faulty P-trap mechanism was exclusive to Tatiana's unit. Furthermore, and this is the kicker, because of that seller's disclosure form, Tatiana was officially legally on notice about prior repairs to that exact bathtub.
Ultimately, the judge ruled entirely in favor of the HOA. The petition was completely dismissed. The judge stated that Tatiana simply failed to prove the association violated any rules. Because the pipe served only her unit, because she inherited the previous owner's shoddy modifications, and because she was on notice from the disclosure, she was left totally responsible for those inherited damages.
This whole case leaves us with 3 absolutely vital lessons if you ever plan to buy property. Number 1, scrutinize those sellers' disclosure forms. Read every single line, because it all matters. Number 2, make sure you completely understand exclusive use clauses in HOA documents. Boundary lines aren't just about walls and paint. And number 3, you have to recognize that inheriting a home literally means inheriting its past mistakes. After exploring these really complex legal boundaries, we're just left with a stark reality about real estate. You really have to ask yourself, if you unwittingly bought a hidden, incredibly expensive defect buried behind the drywall, are you truly prepared to pay the price? Definitely keep your eyes wide open on your next property purchase.